Good luck to you, sir. You can go back with the bailiff.
Okay.
Yes, sir.
I think Mr. Parker might be really good.
Haha, you're funny.
I'm getting there. Let's
I'm in
see.
no hurry, Judge. I'm not like real us.
I didn't say earlier.
I probably don't want to know what you guys are saying. Herbert Kane, 24 DCCR 1083.
We were in county court 2 the other day, and it took literally 20 minutes for somebody to do it. Literally 20 minutes. And I was doing rejection. He tried to say, I believe it. I'm gonna get on Zoom and beat you. So I approached the judge after that plea. I said, by the way, Judge, Mr. Ross is on Zoom. He called his office to get on Zoom.
That's funny.
And he had to wait another hour.
Right here, the tone is already set. The judge isn't debating emotions. She's laying out reality. Competent to stand trial. Second-degree felony. 2 to 20 years. That's not courtroom drama. That's someone's future being measured in decades. And you can tell Kane hears the words, but he hasn't absorbed what they actually mean yet.
All right, sir. Are you Herbert Kane? Is your name Herbert Kane?
Yes, ma'am.
And I'm going to take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Rapon. I've received that report dated August 13th of 2024. Dr. Rapon made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Ms. Malfino? Then at this time, I am going to find that Mr. Kane is competent to stand trial. Mr. Kane, you're charged by indictment with the offense of assault on a peace officer, and that is from April 3rd of 2024. And what that means is if you go to trial and a jury finds you guilty, the range of punishment is between 2 years and up to 20 years.
This is where things start slipping. Kane keeps trying to explain himself, and the judge keeps pulling him back to procedure. And that gap matters, because court isn't about what feels fair in the moment. It's about choices, plea or trial, guilty or not. Everything else is noise.
I understand, but can I ask you a question?
Sure.
If I got, I guess, approached for camping out, but I wasn't there overnight. I just came back from the store.
So here's the thing, what happened surrounding this offense or what they've charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for, and we can let your case go to a jury. That's what we're going through. So it looks like the state has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand?
I understand, but as far as it being my first offense, I don't even get
Here's the thing. Well, here's the thing. The offer is I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand if you go to a jury, what your options are today.
This exchange about the prior conviction is painful to watch, not because it's rare, but because it's common. Kane genuinely believes something was dismissed, reduced, erased. The system doesn't work that way. Paperwork doesn't forget you, even when you think the past is done. And this misunderstanding keeps him stuck, arguing the wrong battle while the real decision clock is ticking.
Okay.
Just so that you're aware, it's not his first offense. He was actually before you in 2018.
Okay.
So they think for
Burglary of a building, it sounds like.
the state jail felony was what
Mm-hmm.
it was dismissed.
I've gone over it.
Okay. So it doesn't appear that it was dismissed, but I just want to make sure now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial.
I don't have a felony on my case as far as what she said.
Look, regardless of that, that doesn't change. Even if you had it, it doesn't change the punishment in this one. Okay, that can be figured out by your attorney very easily if you have one or not. So I just need to know if you want to take the 5 years on this case or if you want to go let a jury decide.
Might I ask her a question?
No, you cannot ask her a question.
I was trying to see if that was a felony or not.
It's a state jail felony. Burglary of a building is what,
It was a, sorry.
Go ahead.
It was a felony conviction with county jail time, so he may misunderstand that he is already a convicted felon.
okay, so it sounds like you got a 1244, which means you got a state jail felony conviction, but you did your time in the Jefferson County Jail. So you do have that state jail felony conviction, even though you did your time in the county jail. That's what the paperwork looks like.
So I got 1244A.
Mhm.
Okay, but from what I understood, it got dismissed.
It doesn't get, it did not get dismissed.
So 1244A is not reduced.
It's where you do your punishment in county jail. And I go over all of that with anyone who's in front of me. So I'm sure I did the same with you.
That's what I'm saying.
It's a state jail felony conviction, but we're going to stop talking about that because it doesn't matter right now.
I was attempting to find out because I ended up going to Judge Clint Woods for like.
That's misdemeanor court.
Exactly, for the reduction of.
That's, listen, it doesn't matter. Whatever that prior is or is not, does not matter on this case right now. This case that you're charged with, second degree felony, assault on a peace officer. The district attorney's office has made an offer of 5 years. Take it or go to trial. The prior is not what is.
When the judge says, "Don't talk over me," that's not anger, that's control. She's trying to force clarity into chaos. Parole eligibility isn't a promise. Good time isn't guaranteed. Prison math isn't clean. This is the moment where Kane needs to stop negotiating with hope and start dealing with facts.
You're asking me questions that your attorney has already gone over. Listen, don't talk over, don't talk over me. Listen, listen, and don't talk for a minute. Because I don't think you've been listening to Mr. Parker. Mr. Parker sounds like has explained everything to you. He's asked the clerk. She has figured out your time, how much credit you have. I don't know how much time. He doesn't know how much time you would actually do on a 5-year sentence because it depends on parole and good time and all of that and how you behave in prison. It's a 5-year sentence. You would be eligible for parole after a quarter of it. That's all we can tell you. And he can tell you how much credit you have. But it's just eligibility for parole. We don't know when you're really going to make it. If you do, that's up to you and how you behave. I need to know if you want to take that or if you want to go to trial.
This is the hardest part of the video. The deadline. Take 5 years now or risk more later. People call this pressure, and it is, but it's also the system saying, we're moving forward with or without your comfort. That's terrifying if you don't fully trust your understanding of the law.
Go get your number and do all the stuff. Mr. Parker's answered all this. I got other stuff to do. Do you want to take the deal or do you not want to take the deal? It's not going to be on the table after today. If you reject this offer today, I'll set your case for trial and this offer will be off the table. I want to make sure you understand that as well. I don't accept plea agreements once I put your case on the trial docket. So what do you want to do?
You can take it to trial.
Okay. So we'll put your case. You understand that I'm not going to take this 5-year deal and it's not going to get any better after today. You understand that, right?
How could it not get better?
Because I'm telling you it's not going to get better. I'm not going to accept a plea agreement for less than 5 years after today because I don't play with my trial docket and just put cases on it. So somebody thinks, well, if I make it last a little longer, maybe I'll get a better deal later. This is your deal today. If you don't want this deal, that's fine. It's either going to have a jury decide, which is fine, or the deal is going to be higher, not lower. Do you understand? And I'm not doing this to just for everybody on the trial docket. If you want a jury to decide, fine. You want the 5 years? Take it today because after today, 5 years is gone.
When Kane says it sounds like he's not allowed to beat his case, that's emotional truth talking. He feels boxed in. The judge pushes back hard because legally he can go to trial. Emotionally, that's a gamble most people aren't ready to take.
Let's see. So you pretty much told me in so many words that you weren't going to allow me to beat my case.
No, I'm completely going to allow you to beat your case. If you want to take it to a jury, 100%, we're going to get it set for trial, and you'll be up for trial whenever the next available trial docket is, and a jury can decide if you're guilty or not. And if you're guilty, then they can sentence you to whatever they think is appropriate. So absolutely, I'm telling you that you can try to beat your case. I just want you to understand that if you think you're putting it on the trial docket to buy some time to get a better deal, and then you want to plead guilty later, that's not going to happen.
And in the end, no relief, no deal, just a trial date somewhere in the future and a new attorney. This isn't a win or a loss yet. It's uncertainty. And sometimes that's the most brutal outcome of all.
No, if you're not, no. If you plead not guilty, then you go to trial. You're either going to say you did it or you didn't do it.
I didn't do it.
If you didn't do it, then we're going to set your case for trial. So we're going to put your case on the trial docket. And so, Mr. Kane, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. If with your permission, I can release him and I can appoint another attorney today who can start getting ready for trial a little quicker. Is that okay with you?
Perhaps Mr. Miller.
You're going to get who I give you. You're going to get whoever is on next up on the list. So it's probably not going to be him. Okay. He's not on our list anymore. Yeah. All right. So do you want to keep Mr. Parker, or can I give you another attorney?
Okay.
Okay. Mr. Parker's released. We'll give you another attorney.